Right now, somewhere in the world, there's a U.S. citizen who genuinely believes their American citizenship is permanent, unshakable, guaranteed for life, no matter what they do next. But what most people don't realize is this: under current U.S. law, there are specific legal pathways that can lead to the loss of U.S. citizenship, even after decades of holding a U.S. passport. Not because you forgot to file a form, not because you moved overseas, not because you upset a government agency, but because certain actions, especially when combined with clear intent, can be treated as you voluntarily giving up your U.S. nationality. And the most terrifying part? Many people only learn these rules after they've already signed something, taken an oath, accepted a job, or joined an organization. And then they're told, this may have consequences for your citizenship. Today, I'm going to walk you through 7 shocking, but completely legal, reasons a person can lose U.S. citizenship under the Immigration and Nationality Act. Some are obvious, some are rare, and some sound harmless until you see how the law works. If you're already a U.S. citizen, this can help you avoid a life-changing mistake. And if you're a green card holder working toward naturalization, this is just as important, because becoming American is only half the journey. Knowing how to protect that citizenship is the other half. By the end of this video, you'll understand the difference between denaturalization and expatriation, the legal concept that protects most citizens, intent, what actions can trigger a citizenship review, and practical steps to reduce risk and protect yourself. Hi, I'm Gabriel. Let's get into it. Disclaimer: I'm not your lawyer. This is general education based on publicly known U.S. law and policy. If you have a situation involving dual citizenship, foreign government work, military service, or renunciation, talk to a qualified U.S. immigration or nationality attorney. First, 2 totally different ways people lose U.S. citizenship. Before we jump into the 7 reasons, you need one critical foundation. Not all citizenship loss happens the same way. Under U.S. law, there are 2 main legal paths. Path number 1, denaturalization, only for naturalized citizens. Denaturalization applies to people who became citizens through the naturalization process. In simple terms, the government claims you should never have been granted citizenship in the first place, usually due to fraud or misrepresentation hiding a disqualifying criminal history, lying about immigration facts, or an illegal grant of citizenship. Denaturalization is serious, typically involves court action, and the stakes are enormous. But that's not what today's video is focused on. Path number 2, expatriation, loss of nationality based on your actions. This is the one most people don't understand. Expatriation means a U.S. citizen voluntarily performs an act listed in federal law that can lead to loss of nationality, and does it with the intent to relinquish U.S. citizenship. The core statute here is the Immigration and Nationality Act, often referenced as INA Section 349, 8 U.S.C., Section 1481. It lists specific expatriating acts. Now here's the single most important concept of this entire topic. The government usually must prove intent. Modern Supreme Court decisions made citizenship far more protected than many people realize. In most real-life cases today, the government can't just take your citizenship because you performed one of these acts. They generally must show you did it voluntarily and with intent to give up U.S. citizenship. That word, intent, is the key that explains why millions of Americans live abroad, hold dual citizenship, and live international lives without losing their nationality. So, as we go through the 7 reasons, keep asking this question: did the person clearly intend to stop being American? All right, with that foundation in place, let's go through the 7 legal reasons. Reason number 1, voluntarily naturalizing in a foreign country. This one shocks people because it sounds so common. Under the INA, voluntarily obtaining citizenship in another country can be an expatriating act. Now, let's clear up the confusion right away. Dual citizenship itself is not automatically a problem. Millions of Americans legally hold 2 passports. Many were born with another citizenship, inherited it through parents, or automatically acquired it under another country's law. That alone usually does not threaten U.S. citizenship. The risk is voluntary naturalization as an adult. If you apply for foreign citizenship as an adult, go through a formal naturalization process, and especially if that process includes strong statements of allegiance, it can trigger questions. But again, intent is the deciding factor. In modern practice, the State Department often presumes many Americans who naturalize abroad do not intend to give up U.S. citizenship, unless the facts show otherwise. When does it become dangerous? It becomes risky when you explicitly state you are giving up U.S. citizenship. You sign documents renouncing prior allegiance to the U.S. You behave consistently like someone who has abandoned U.S. nationality. For example, refusing to use a U.S. passport when required, or telling officials you are no longer American. When is it usually not an issue? If you naturalize abroad for practical reasons, work authorization, family unity, residence rights, and you still keep and renew your U.S. passport, maintain U.S. ties, file required U.S. taxes if applicable, and continue to identify as a U.S. citizen, then the intent to relinquish often isn't there. Practical takeaway. If you're considering foreign citizenship, don't treat it like a casual paperwork event. Read what you're signing, understand the oath language, and if anything suggests renunciation of the U.S., get legal advice. Reason number 2. Taking a foreign oath of allegiance. This is closely connected to number 1, but it matters enough to stand alone. Many countries require an oath for citizenship, government roles, military service, sometimes even certain licensed professions. Under INA 349, taking an oath of allegiance to a foreign state can be an expatriating act in certain circumstances. Not every oath is treated the same. Some oaths are symbolic or ceremonial. Others are explicit and sweeping. What matters is the exact wording, the context, and what you did afterward. Low-risk scenario, common. You take a standard citizenship oath in a friendly country while still actively maintaining U.S. citizenship. You continue using your U.S. passport. You keep your ties. You never claim to have renounced the U.S. In many cases, that does not show intent to relinquish. High-risk scenario, more serious. You take an oath that explicitly says something like, "I renounce all other allegiances," or you sign a declaration that you reject the United States, or you tell officials you no longer want to be an American citizen. Now you've created evidence that can be interpreted as intent. Practical takeaway. The oath itself doesn't always destroy citizenship, but if the oath language is explicit, or your actions afterward show rejection of U.S. nationality, then it becomes legally dangerous. Reason number 3. Serving in a foreign military. This topic gets emotional fast, and the law here is nuanced. Serving in the armed forces of another country can be an expatriating act, especially when combined with an officer role, an oath of allegiance service for a hostile force, or conduct that clearly indicates abandoning U.S. loyalty. Is all foreign military service treated like betrayal? No. Real life is complicated. Some Americans are dual citizens. Some have mandatory service requirements in another country. Some serve in allied forces. But the risk increases in these situations. The foreign force is hostile to the U.S. You serve as a commissioned or non-commissioned officer, depending on circumstances. You take an oath that conflicts with U.S. allegiance. You engage in actions against U.S. interests or forces. And again, intent is central. Practical takeaway. If you're a U.S. citizen and you're considering any foreign military service, this is absolutely not Google it and hope. You should get professional advice before you commit, because the facts matter. Reason number 4. Accepting certain employment with a foreign government. This one surprises people because so many Americans work abroad. Under the INA, Accepting certain foreign government roles can be an expatriating act, particularly if the position requires an oath of allegiance, or the person is also a national of that country, or it's a policy-level position where loyalty and authority are a serious concern. What the law is really concerned about. The law isn't aimed at normal jobs abroad. It's focused on situations where a U.S. citizen appears to have shifted primary political loyalty to another state. Usually low risk, teaching at a public university, routine administrative work, technical or advisory roles without political power, non-policy employment that doesn't require allegiance oaths. Higher risk, senior government leadership, high-level policy-making positions, diplomatic roles that strongly conflict with U.S. allegiance, jobs that require explicit loyalty oaths, rejecting other citizenships. Still, even then, intent must typically be shown. Practical takeaway. If a foreign government job requires an oath, or it's a high-level role, treat it as legally sensitive. Get advice before signing anything. Reason number 5. Formal renunciation of U.S. citizenship abroad. This is the most direct and the most final route. A person can lose U.S. citizenship by formally renouncing it in front of a U.S. diplomatic or consular officer abroad. This is not ambiguous. This is not about interpretation. This is a deliberate act. What renunciation looks like in real life. Typically, you appear in person at a U.S. embassy or consulate. You sign specific forms. You take an oath of renunciation. The U.S. government confirms the decision is voluntary and informed. Renunciation is generally permanent and extremely difficult to undo. Consequences can include losing the right to live in the U.S. as a citizen, losing a U.S. passport and consular protection as a citizen, complications visiting the U.S. in the future, potential U.S. tax consequences for certain individuals, an area where you should consult a tax professional. Practical takeaway. People renounce for many reasons, but nobody should do it casually, emotionally, or without understanding the consequences. Reason number 6. Renouncing U.S. citizenship. Inside the U.S. during wartime. Rare. This is one of the least known provisions because it's rarely used. Normally, renunciation happens abroad. But U.S. law contains a wartime exception allowing renunciation from inside the U.S. under strict procedures. This is not something most people will ever encounter. It's tightly controlled, and the government has broad discretion in how it's handled. Practical takeaway. For almost everyone watching, this is more of a law on the books than a real-world pathway. But it exists, and it shows how comprehensive nationality law is. Reason number 7. Treason, armed hostility, or attempting to overthrow the government by force. This is the most severe category, and the one most people will never come anywhere near. U.S. law includes provisions for loss of nationality tied to treason, rebellion or insurrection-type offenses, bearing arms against the U.S., or similar extreme conduct. 2 important clarifications. 1. This is not about speech or protest. Criticizing the government, protesting, political activism, or unpopular opinions are not grounds for citizenship loss. The U.S. has strong constitutional protections for speech. 2. These cases are rare and legally complex. Treason prosecutions are historically uncommon, and legal standards are high. And even in serious national security matters, modern constitutional doctrine still emphasizes voluntariness and intent. Practical takeaway. This category exists for extreme scenarios, not everyday political disagreement. The thread that connects all 7. Intent, and why that's good news. Let's zoom out. After hearing 7 different ways citizenship can be lost, it's easy to feel anxious. But here's the reassurance. U.S. citizenship is one of the most protected legal statuses in the world. In most modern cases, citizenship is not lost accidentally. The system generally requires a listed expatriating act, voluntary action, and evidence that you intended to give up U.S. nationality. That's why Americans can live abroad for decades, hold dual citizenship, work internationally, and still remain fully American. The law is designed to protect ordinary people living global lives. Practical ways to protect yourself. Common sense guidance. If you want the real-world checklist, here it is. 1. Don't guess. Get advice for high-risk choices. If you're considering foreign naturalization, foreign military service, foreign government policy, roles, or renunciation, talk to a qualified attorney first. 2. Maintain clear ties to the U.S. These can help show you never intended to relinquish citizenship. Keep your U.S. passport current. Comply with U.S. tax filing obligations if applicable. Maintain U.S. bank accounts, property, family ties where possible. Visit the U.S. when you can. Avoid statements that you are no longer American. 3. Read every oath and document carefully. If wording suggests renunciation of U.S. allegiance, that's a red flag. Don't assume it's meaningless ceremony. 4. Keep records. If intent ever becomes a question years later, documentation matters. Passports, travel history, tax records, proof of continued U.S. ties, copies of foreign naturalization papers and oath language. 5. If you think you already did something risky, don't panic. Remember, the presumption generally favors retaining citizenship unless intent to relinquish is clear. Get competent advice before spiraling. Closing. Confidence, not fear. Here's the truth. These laws are real, but they are not designed to trap ordinary people. They exist to handle rare, serious, or deliberate situations where a person truly chooses to sever their bond with the United States, or acts in a way fundamentally incompatible with citizenship. If you live honestly, stay informed, and make major nationality decisions carefully, your U.S. citizenship is incredibly secure. If this video helped you understand something important about your legal future, consider subscribing and turning on notifications, because immigration and citizenship rules don't just change on paper, they change lives. I'm Gabriel. Thanks for watching, and I'll see you in the next update.